Good morning. This is David Olshan of Nevada Legal Services. It's Monday, April 26th, 2021, and this is your COVID-19 update. It's hard not to talk about the failures of the Nevada legislature in light of the problems over at the Employment Security Division. Alyssa Cafferata basically said they expect 10,000 new cases, petitions for judicial review. We need more money, more attorneys. And the legislature basically just bought it. The real question is, why don't they just follow the law? They wouldn't need attorneys if they do follow the law. People probably with greater transparency and information would understand what's going on over there, and they wouldn't necessarily believe the director of DETR when these issues come up. They did kill AB 292, which did help workers. So far, the legislature has done nothing in the special session or in the current session. They do have SB 75, which basically helps the Employment Security Division, gives them greater rights and greater resources. Why don't they do that for the workers? Well, we just don't know. Let's talk a little bit about overpayments. If you applied for PUA when you were eligible for regular unemployment or vice versa, you will see an overpayment. If you reported income incorrectly, let's say you put your gross income instead of your net income, that will result in an overpayment. If you don't have documentation regarding your 2019 or 2020 income, that could be a basis for denial of PUA and an overpayment. We also have another issue. Sometimes there's mystery balances on your EBT card. You don't know where the money's coming from. You may be eligible for it, and you don't know whether you should spend it. These are hard choices to make, especially when the Employment Security Division doesn't call you back, doesn't explain what's going on. And of course, if they hire attorneys that litigate these cases and deny you benefits, but don't help people who have these hard choices and can deal with overpayments or just balances on their EBT card, maybe they want to direct the resources where they're needed. If you get an overpayment notice from the Employment Security Division and want to contest it, do it quickly. You have 11 days to contest an overpayment, and the Employment Security Division can waive an overpayment if it's against equity and good conscience, and it's not due to fraud or willful non-disclosure. Now, if you have applied for the wrong program, yes, it's against equity and good conscience, but the Employment Security Division will ask about your budget and whether you can afford to pay it back. That's totally erroneous. It really doesn't matter. If you made a mistake, you shouldn't be charged with an overpayment. If you cannot waive your overpayment in a hearing with the Employment Security Division, there's still hope. You can file for Chapter 7 bankruptcy protection and discharge that overpayment if it's not based on fraud. So if you have a problem with the Employment Security Division, an overpayment notice, or any other issues, please do an online intake at nlslaw.net, and I will be back with more COVID-19 updates.